Okay, welcome back to Law and Legal Process. I'm your Professor Shane Nelson, and today we're going to be continuing our discussion into the judicial system. So today we're moving into a very practical question that needs to be answered, and that question is, where should a lawsuit be heard? Now that question may sound technical, but it can completely shape the outcome of a case. The same claim might look very different depending on whether it's filed in a state court or federal court, for instance, whether it could be in a different state like Florida or Washington or in New York. So different courts might have different procedural rules, different filing deadlines, different juries, different judges, and different strategic advantages. And before we get into our cases today of Carnival Cruise Lines v. Shute and Guaranty Trust Co. v. New York, we're going to begin with a cumulative review for quiz number 3. And that review connects to the earlier material on congressional power, Brown v. Board of Education, judicial decision-making, and Roscoe Pound, and onto the new material of the courts and forum choice. So the first part of today's lecture is the review. The quiz questions are going to ask you to remember the Commerce Clause, the Taxing Clause, the Necessary and Proper Clause, United States v. Lopez facts, NFIB v. Sevilius, Brown v. Board of Education, Richard Posner's theories of judicial decision-making, and Roscoe Pound's view of how the law develops. The second part of the lecture moves into new material. We're going to be talking about the choice of forum, where meaning of a lawsuit is filed. And then we're going to move into Carnival Cruise Lines v. Shute to ask whether a company can contractually require customers to sue in a specific court. And finally, we'll use Guaranty Trust Co. v. New York to ask whether federal courts hearing a state law claims must follow those state rules when those rules could affect the overall outcome. Now let's begin with the 3 constitutional clauses that are central to the quiz. First, the Taxing Clause gives Congress the power to lay and collect taxes, duties, imposts, and excises in order to pay debts and provide for the common defense and general welfare of the people. Second, the Commerce Clause gives Congress the power to regulate commerce with foreign nations and among several states, and with Indian tribes. Third, the Necessary and Proper Clause gives Congress the power to make laws necessary and proper for carrying out powers listed in the Constitution. United States v. Lopez is important because it placed a limit on Congress's Commerce Clause authority. The court held that Congress could not use the Commerce Clause to prohibit possession of a gun near school. The activity was not sufficiently economic and not sufficiently connected to interstate commerce. NFIB v. Sevilius is different. There, the court considered the Affordable Care Act's individual mandate. The court rejected the argument that the mandate was valid under the Commerce Clause, but upheld it as a valid exercise of Congress's taxing power. Brown v. Board of Education is one of the most important Supreme Court cases in American history. The court held that racial segregation in public education violated the Equal Protection Clause of the 14th Amendment. So the key phrase here that I would suggest you to remember is that separate educational facilities are inherently unequal. And this matters for our broader course because Brown demonstrates the power of the courts to interpret constitutional principles and reshape public institutions. It also gives us a bridge into today's topic. Courts are not just neutral buildings where disputes happen. The courts are institutions with authority, procedures, and power. Richard Posner gives us several ways to think about how judges actually make decisions. The legalist theory says that judges decide case based on only the law. This is the traditional view, and it's usually the preferred theory of practicing lawyers and judges. The attitudinal theory says that judges decide primarily based on their political preferences. This is often associated with political science approaches to the courts. The strategic theory says that judges may consider the reactions of other judges, legislators, and the public, or other institutions. The psychological theory says that judges' preconceptions and biases may shape how they understand facts, legal rules, even if they're not consciously aware of it. The economic theory says that judges are rational, self-interest actors who respond to incentives and disincentives. The organizational theory focuses on judges acting within institutional structures, where they may be influenced by their court or their relationship to other legal actors. And finally, the pragmatic theory says that judges will often decide by focusing on consequences and practical outcomes of these cases. And this matters today because Carnival Cruise Lines and Guaranty Trust are procedural cases, but they're also about judicial reasoning. The court is not just asking what's the rule here, the court is asking what will happen if we enforce or refuse to enforce this procedural rule. Roscoe Pound helps us understand that law is not just a set of rules. He describes legal precepts as the legal principles and the rules themselves. Legal technique refers to traditional methods judges and lawyers use to interpret and apply those rules. Legal ideas refer to the broader philosophical, political, and ethical ideas about what the law should be and what the law should do to accomplish things. This is useful for today's cases because choice of forum is not just technical, it also involves ideals. Should consumers be protected from fine print? Should businesses be allowed to reduce litigation costs? Should federal courts produce different outcomes than state courts? These are all procedural questions, but they're also questions about fairness, efficiency, federalism, and access to justice. Newer material. So now we transition into the newer material. A person might have a legitimate injury. A plaintiff might have a valid legal theory. But that doesn't automatically mean that the plaintiff can sue you anywhere. The legal system asks threshold questions before reaching those merits. Does the court have subject matter jurisdiction? Does the court have personal jurisdiction over the defendant? Is this the proper venue? Is there a contract that requires suit in a particular forum? If the case is in federal court but involves state law, then which rules will apply? All of these questions are procedural, but they can determine whether plaintiffs get into a court at all. Choice of forum refers to the decision about where to file a lawsuit. Schubert explains that plaintiffs might choose one forum over another for many reasons. A forum may be closer or more convenient. A plaintiff's attorney might consider whether a court is known for larger verdicts, whether the forum is rural or urban, socioeconomic factors, and whether the reputation of the parties are in that community. Plaintiffs might also prefer federal court if federal procedural rules are more favorable than state rules. And this is why procedure matters. Forum choice can affect leverage, settlement, costs, and even whether the case survives. Now, all of these terms you see here are related, but they're not identical. Jurisdiction is the court's legal power. Subject matter jurisdiction asks whether the court has authority over the category of a case. For example, a bankruptcy court hears bankruptcy cases, while a family court handles family law matters. Personal jurisdiction asks whether the court has authority over the defendant, and this is where international shoe and helicopteros fit in. Courts need a constitutionally sufficient connection between the defendant and the forum. Venue asks whether the case is in the proper geographic location within a court system. A forum selection clause is different. It is a contractual provision where the parties agree in advance that any dispute might be litigated in that particular location. Carnival Cruise Lines v. Shute is about whether that kind of clause can be enforced against ordinary consumers. Carnival Cruise Lines v. Shute matters not just because it's about cruise tickets, it's about standard form contracts. Most consumer contracts are not negotiated. You don't sit down with Apple, Netflix, Amazon, Carnival, or your cell phone company to negotiate each provision you're signing. Instead, the company writes the contract and the consumer either accepts it or they don't use the service. And that's why this case raises a larger question regarding when the court should enforce fine print contract terms against consumers. In Shute, the key provision was a forum selection clause requiring lawsuits against Carnival to be filed in Florida. Okay, so let's discuss some of the case facts here. So the Shutes lived in Washington. They purchased tickets for a Carnival cruise. Carnival was headquartered in Florida, and the ticket contained a clause requiring lawsuits to be filed in Florida. Miss Shute was injured while on the Carnival cruise, and the Shutes sued Carnival in Washington. Carnival argued that the case had to be dismissed because of the Florida forum selection clause. Now, let's slow down with the facts here because this is of paramount importance. The Shutes were residents of Washington state. They purchased tickets for a Carnival cruise, and Carnival Cruise Lines were based in Florida, so the tickets included the forum selection clause stating that all disputes had to be litigated in Florida. And during the cruise, when Miss Shute was injured, the Shutes sued Carnival in federal court in Washington. So from their perspective, Washington made sense because it's where they lived, and it was just far more convenient for them. So traveling to Florida to sue a major corporation would have been expensive and just more burdensome for the Shutes. Carnival responded to this by pointing to the ticket contract. Carnival argued that Shutes had agreed to sue only in Florida, so Washington court could not hear the case. So the factual problem here is simple. The injured consumers want to sue where they live, but the company says that the ticket requires them to sue across the country. So the issue here is the forum selection clause printed on a cruise ticket enforceable against passengers who did not bargain over the clause. So essentially, this is just about whether the forum selection clause should be enforced. And the Shutes had a strong fairness argument. They were individual consumers, they did not negotiate the clause, and they likely had no realistic ability to change that contract. So if they wanted to go on a cruise, then they had to accept Carnival's standard terms. Carnival had a different argument. Carnival carried passengers from many different states, and if every passenger could sue Carnival anywhere, Carnival could face litigation from all across the country. So that would just be essentially too far unpredictable and expensive for the cruise ships. And Carnival argued that selecting Florida as the forum only made sense because Carnival was headquartered there, and because centralized litigation could reduce the costs. So the case therefore pits access to justice against contractual predictability. So now we get to the overall holding. The Supreme Court sided with Carnival. The court held that the forum selection clause was enforceable. The court reasoned that Carnival had a legitimate business interest in limiting the places where it could be sued. So because Carnival served many passengers from many different locations, it would be ineffective and expensive to defend lawsuits from every single state. The court also suggested that the forum selection clauses create predictability. Passengers and companies know in advance where disputes will be heard. The court was also concerned with cost. If Carnival has to litigate everywhere, the cost of litigation might rise, and the cost could be passed on to consumers through higher ticket prices. So importantly, the court did not treat the lack of bargaining as automatically fatal, and that's one of the most controversial parts of this case. The passengers did not negotiate the clause, but the court still enforced it. The major takeaway is that the forum selection clauses can be enforceable even when they appear in standard form contracts. And this matters because modern life is just full of these agreements. So every time, for instance, you click on an I agree to download an app, or you sign up for a streaming service, You buy a ticket someplace, you're using a website, you might be agreeing to terms where disputes might already be resolved. So, from a business perspective, Shute makes sense. Companies need these forms of predictability, and they want to control litigation costs. But from a consumer perspective of you and I, it's a little bit more troubling, because a person with legitimate injury might be discouraged from bringing a claim if the contract requires them to sue from far away. So the deeper question is not just whether the clause was technically in the contract, it's really about whether enforcement of these clauses promotes fairness or simply gives repeat player corporations a procedural advantage. And this is where the quiz review connects to the new material. A legalist might say that the clause was in the contract and courts should enforce the contract as written. A pragmatic judge might focus on the consequences. If cruise lines can be sued anywhere, costs rise. If forum clauses are enforced, litigation becomes more predictable. So Roscoe Pound helps us see the layers. The legal precept is the rule about enforcing the forum selection clauses. The legal technique is how courts interpret the clause. The legal ideal here is the deeper question of whether the law should value effectiveness, fairness, predictability, access to courts, or some balance among them. Carnival Cruise Lines is about private parties using a contract to choose the forum. Guaranty Trust Co. v. New York is about a different forum problem, the relationship between state courts and federal courts. Sometimes a case is based on state law end up in a federal court because of diversity jurisdiction. Diversity jurisdiction generally allows for federal courts to hear cases between citizens of different states, assuming the amount in controversy requirement is met. But that does create a problem. If the claim is based on state law, but the case is in federal court, then which rules would apply? If federal courts apply different rules than state courts, then parties may choose federal courts simply to get a different outcome, and this is called forum shopping. So to understand the case of Guaranty Trust, first we need to go over the Erie Doctrine. The Erie Doctrine comes from Erie Railroad v. Tompkins, and the basic idea is that when a federal court hears a state law claim, the federal court must apply state substantive law. This protects federalism. State law should mean the same thing whether it's applied by a state judge or a federal judge. Schubert explains that the Erie Doctrine generally requires federal judges to apply the same conflict of law rule that would be applied in the courts of the state where the federal court is located. But the Erie Doctrine does create a difficult question. What counts as substantive and what counts as procedural? And this is where the case of Guaranty Trust becomes important. Okay, so let's dive into the facts of Guaranty Trust Co. v. York. York brought a claim in federal court based on state law. The case was in federal court because of diversity jurisdiction. New York's statute of limitations would have barred this claim in state court. York argued that federal equity practice should allow the claim to proceed. Guaranty Trust argued that federal court should apply the state limitations rule. So to be clear here, York brought a claim in federal court. The claim was based on state law, but the case was in federal court because of diversity jurisdiction. And the problem was the timing. So under New York law, the statute of limitations had expired. That means if York had filed in New York state court, the claim would have been barred. York argued that because the case was in federal court, the federal court should not be bound by the state limitations rule in the same way. So York wanted federal equity practice to allow the case to proceed. Guaranty Trust argued the opposite. It argued that if the state statute of limitations would bar the claim in state court, then the same claim should also be barred in federal court. The issue here is not simply about filing deadlines. The issue is whether going to federal court should allow a plaintiff to escape a state law rule that would otherwise defeat the case. So the issue here, must a federal court sitting in diversity apply a state statute of limitations when ignoring it would change the outcome? And of course the key concern here is that a plaintiff should not get a different result by merely choosing a different federal court instead of a state court. And also, to explain further, a statute of limitations is a law that sets the time period within which a claim must be filed. Schubert explains that statutes of limitations require claims to be brought within a reasonable time so that opposing parties have a fair opportunity to defend against the claim and they're not surprised by stale claims. So this is not just a minor technical rule. A statute of limitations can decide whether the plaintiff has a case at all. And if a claim is barred in state court but allowed in federal court, then the choice of forum would change the outcome. So the Supreme Court saw that as a major problem. Now, the holding here was the federal court had to apply the state statute of limitations. So the rule here was if applying a different federal rule would substantially affect the outcome, the federal court should apply state law. So the basic idea is this: if ignoring the state rule would substantially affect the outcome of the litigation, then the federal court should apply the state rule. In other words, the outcome should not depend simply on whether the plaintiff filed in federal court rather than state court. In York, the statute of limitations was outcome determinative because it decided whether the plaintiff's claim could proceed at all. If the state deadline applied, then the case was barred. If the federal court ignored the state deadline, then the case could continue, and that difference is just far too significant. Now, the case of Guaranty Trust matters because it tries to prevent forum shopping. Forum shopping occurs when parties choose a court not because it's naturally connected to the dispute itself, but because it gives them a strategic advantage. And the concern here in York was that the plaintiffs would file in federal court to avoid state rules that would hurt their case. The court wanted to prevent federal court from becoming a way around state law. If the case is based on state law, then federal court should not produce a substantially different result simply because it's federal. And this is also a federalism issue. State law belongs to the states. Federal courts should not distort state law when hearing state law claims. But this is where things become a little bit more complicated, because not every state rule applies in federal courts. Schubert explains that where state and federal procedural rules differ, the Erie Doctrine does not normally require federal courts to apply state procedural rules. So federal courts generally apply federal rules of civil procedure unless doing so would significantly affect substantive rights, encourage forum shopping, or promote discriminatory application of the law. So this is all of the essential things you need to remember here. The rule is not simply federal court always applies state rules. The better way to think of this is that federal court applies state substantive law, federal procedural law, but must be careful when a supposedly procedural difference would affect the outcome or encourage forum shopping. And that's why the case of York is so important here, because it really shows that a procedural-looking rule, such as the statute of limitations, may be treated as an outcome-determinative case. So comparing the two cases, they're definitely different, but they are connected. Carnival Cruise Lines asks whether a private company can use a contract to require litigation in a very specific place, and the concern is consumer fairness versus business efficiency. Guaranty Trust asks whether a federal court can apply a different rule rather than a state court would apply. So the concern here is federalism, consistency, and of course forum shopping. But both cases teach the same broader lesson of procedure is power, and students often think of the law as mostly about who is right and who is wrong and what the facts are. But lawyers know that procedures can shape everything. And just simple things about like where the case is filed and who hears the actual case itself, what the deadlines are and which rules are governing the court, whether a contract limits the forum, all of that can determine whether or not your claim survives. So with this said, getting on to our final review here, for the quiz, remember the case of Lopez, remember Congress's Commerce Clause, remember the case of Brown v. Board of Education, go over the pound legal theory, and as for today's cases, just remember this. Carnival Cruise Lines v. Shute teaches that a forum selection clause in standard forum consumer contract can be enforceable even when the consumer didn't necessarily negotiate it. And with Guaranty Trust Co. v. York, this really teaches us that federal courts sitting in diversity must apply the state rules when ignoring those rules would substantially affect the outcome. But with this said, I thank you for your time, and that concludes today's lecture.